Welcome, everyone, to the Latham and Watkins Forum. Today we're going to be covering the Supreme Court term, the upcoming term, as well as reflecting on the term that recently concluded in July. That was a blockbuster term with lots of cases on hot-button issues like the Second Amendment, abortion, administrative law, and presidential power. The upcoming term will be equally epic, I think. There are some really important cases on the docket, including a case about the provision of gender-affirming care from the Sixth Circuit, another case involving the Second Amendment, another case involving free speech, and there's also the likelihood of challenges related to the upcoming November 2024 election. So it's going to be a big time at One First Street, and we have a fantastic panel with us today to break it all down. Joining me today, to my immediate left, is Kelsey Corcoran. Kelsey Corcoran is the Supreme Court Director at the Institute for Constitutional Advocacy and Protection and a senior lecturer at Georgetown University Law Center. She is a well-known member of the Supreme Court Bar, having argued multiple cases before the High Court, including, just last term, Atchison Hotels versus Laufer, a disability discrimination case under the Americans with Disabilities Act, as well as City of Grants Pass versus Johnson, a case regarding the criminalization of homelessness. Also with us today, to Kelsey's left, is Anne Marimo of the Washington Post, where she covers the Supreme Court. Anne is a veteran journalist, having covered state government and local politics in the Bay Area with the San Jose Mercury News and in New Hampshire with the Concord Monitor. She joined the Washington Post in 2005 and recently came to the Supreme Court beat just last year. Right. To Anne's left is another veteran court litigator, Roman Martinez, who is a partner in the DC office of Latham and Watkins. He's a member of the firm's appellate practice. He has argued 14 cases in the Supreme Court, including Loper Bright Enterprises versus Raimondo, which the court decided last year, a major administrative law case. So we couldn't have a better panel to talk about last term and also to look forward to the upcoming term. So to get things started, let's talk a little bit about October term 2023. So we saw lots of hot-button issues: abortion, guns, free speech, everything that you could want if you were an avid court watcher, or maybe you didn't want if you were an avid court watcher, but lots to think about. What did these decisions tell us about the dynamics among the justices at the court? Anyone can jump in.
Okay, I'll go first. This is not insightful at all. I think everyone who watches the court would say this, but up until this term, since Justice Ginsburg died and was replaced by Justice Barrett, it's really functioned as a 3-3-3 court, which isn't to say that with the one pair being Justice Alito, Gorsuch, and Thomas, and then we have Barrett, Kavanaugh, and the Chief, and then we have Jackson, Sotomayor, and Kagan in the final third. And it's not to say that the Barrett, Kavanaugh, and the Chief are centrist in any way. I think all 6 of those justices are right of center, but they seem to vote in ways, and it would come out quite a bit in dissents from denial of taking cases, right? The 3, Gorsuch, Thomas, and Alito would say, I wish we had taken this case. And what you got was a sense that they were just more ambitious in wanting to kind of push the court to take cases now that there was this supermajority on the conservative side. I think, again, this isn't particularly insightful. I think everyone has said this. That exploded this year, at least in June. It seems much more now like a 5-1-3 court with Justice Barrett going kind of her own way. We'll probably talk about some of those cases today, and Justice Kavanaugh and the Chief joining the other 3 and a lot of pretty explosive opinions that we'll talk about. So,
Ramon, did you want to jump in?
Okay. Yeah, we could spend a whole panel talking about Justice Barrett. I think she really was the justice to watch and really unpredictable throughout the term. One thing I wanted to talk about was the number of separate writings by the justices this term. I saw a statistic that there were more separate concurrences, dissents, opinions at any time in the court since 1937. And I was really struck by, even when the court was agreeing, as they did in Rahimi, the case about the federal law that allows the government to take firearms away from domestic violence abusers. So even when they agreed on the outcome that they should uphold the law, they were all writing separately. And I found that very confusing as a journalist trying to figure out what's the main message here. But we saw that also even in the immunity case, you had Justice Jackson writing on her own. In the case that they got rid of about abortion from Idaho, you had lots of separate writing. So I thought that was another really interesting takeaway, that there was lots of disagreement even when they had the same judgment at the end of the day.
Disagreements in agreement.
Yes.
I mean, I think going back to Kelsey's point about the 333 court, I have a little bit of a different take on it. I actually think this term continued to show the sort of 333 framework for looking at the court being valid. I think that's true despite the fact that you saw more of the traditional kind of alignments in maybe the cases that were the very highest profile at the end of the year, the Trump case, and maybe the case that I argued involving Chevron deference. But I do some of these panels, including with some of my friends who are up here with me, at the end of the term, and I have a little cheat sheet that I create for myself on like the big cases. And I think we probably have different views on the merits of a lot of these cases, but if we were to come together and put together a list of like the important cases, we would probably agree on what they were. This year, my list had 20 kind of big cases on it, which is more than in past years. And so the interesting thing for me there, I saw the liberal side of the court being in the majority in 11 of those 20 cases, which suggested to me that it's not, like sometimes you have this narrative of sort of the runaway, conservative majority dominating the court. I don't think that's quite right. If you look at the statistics overall, the middle of the court, the middle three justices, the Chief, Justice Kavanaugh, Justice Barrett, were in the majority 96%, 95%, and 92% of the time, respectively. The right side of the court, the justices traditionally thought of as to the right of them, Thomas, Alito, and Gorsuch were in the majority 80 to 81% of the time. And the left side of the court was in the majority 71 to 72% of the time. So you see, a couple things to take away from that. You see most of the justices are in the majority a lot of the time. There are differences, but there are differences between the right and the left sides. But I think there are also very significant differences between the middle three justices and the ones, more to their right and certainly on their left.
We're off, right? So let me push back.
Yeah.
So in those cases where you see them sort of this 3-3-3 split, we still saw 6-3 supermajorities in the really big cases. So I'm thinking about the immunity case, although we do have a separate writing from Justice Barrett. Loper Bright, for example, there's a 6-3 split. Does it matter if there's some sort of wiggle room on where the three in the middle are, if the middle really isn't the middle?
Well, I think I would disagree. I think you're certainly right that in those cases you saw more of a 6-3 kind of look. On the other hand, I think there were a lot of cases that if you had asked us before the decisions come out, are these big cases or not, we would have said yes, and that's where we saw some disagreement. So the ones I would point to as cases where the three in the middle disagreed with the three on the right side, at least in some cases it's sort of like 2-1 within each block. But the Moyle case, which is one of the abortion cases, the net choice case, the Murthy case involving, sort of
Job
White
owning.
House and government officials calling up social media companies to affect their content moderation, the CFPB case, the Purdue bankruptcy case, the Moore tax case. These are all cases that maybe it's not Trump and maybe it's not Chevron deference, but I think they're all like big, important cases. And those are ones where we see very meaningful differences between the middle three justices and Justices Alito, Gorsuch, and Thomas.
Do you agree, Kelsey?
Well, so I would just say, and this was my initial thought when you were doing your numbers, I think that they're a little inflated by at least the first three cases you named, which were the ones that came to my mind, Murthy, Moyle, and Moody, the net choice case, because what the court ended up doing in each of those is kind of punting the issue, right? And so you see the majority coming together you see the progressives coming in and saying, okay, yeah, let's not decide that right now, or we're not going to reach the issue. And so I don't know that I think you need to parse that out when you're kind of including which decisions they were in the majority on.
I mean, I think on the social media cases, those are really cases that were brought by either, there were prompted by either conservative-leaning states or conservative-leaning litigants pushing kind of somewhat forward-leaning theories of the law. And I think in both those cases, although you're right that there are like heavy procedural aspects to how they were resolved, ultimately I think you see the right side of the court actually being pretty unhappy with the resolutions of those cases, and not glad that they were resolved without addressing some of the substantive merits.
Anne?
Yeah, I'll just add that we now know, because of reporting by my colleagues from other outlets, that in the net choice case, I think it is, Justice Alito initially had that decision and wanted to go in a certain direction, and then Justice Kagan was able to bring, I think, Justice Barrett and Justice Jackson over to form a different majority.
Right.
So I thought that was fascinating.
Did you want to say
I
more?
was just going to say, just one more thing about those three is that when you're talking about the social media and First Amendment kind of context, they are almost sui generis because you start to see across the board on the social media First Amendment issues kind of divisions, right? That those don't tend to align kind of Republican, Democrat the same way.
So all very good points. Anne raises another important issue. We've seen some justices kind of being put out into the wilderness and some coming back into the fold. On strict scrutiny, after the Dobbs decision, we joked, I don't know, we probably weren't joking. We said that the Chief Justice seemed to have lost control of the conservative supermajority and was really the Chief Justice in name only, certainly in that case. And it seems like this year he has really reasserted himself with the conservatives and perhaps has taken control of this court. We've also seen that Justice Alito, who had a more muscular presence in other terms, being somewhat diminished. He only had 4 majority opinions, and as you say, according to that reporting, he may have lost 2 majorities because he was unwilling to moderate his views and to keep the majority together and wanted to do something a little more extreme for some members of the court and lost the majority that way. How do you think of the Chief Justice? I mean, is he sort of in full flower in terms of his authority with the supermajority? And what about the other members of the court and how they slot in here in terms of where they're able to exert influence?
I'll let Roman start.
So I clerk for the chief, so I'll take a crack at that one. I think, Melissa, you're exactly right. I think the chief, with respect to this term, really did exert a lot of control over the docket. As I mentioned earlier, he was in the majority in 96% of the cases, which is pretty remarkable. He also exercised, every justice gets the same number of votes, but the chief does have a lot of control by virtue of his seniority in terms of assigning opinions. And he seemed to write the opinions in many of the very biggest of the top half of my list of 20 cases. So in the 3 sort of Trump-related cases, he wrote the opinions. In the 2 biggest administrative law cases, he wrote the opinions, and then he wrote the opinion in the big Second Amendment gun case, and I'm sure there were maybe 1 or 2 others as well. So I totally agree. He was very a dominant force at the court. I think the thing where I would maybe disagree a little bit is just on the Dobbs example and sort of the premise being that like he has all this power and it's his court to begin with. I think in some sense that's always been true because he's kind of in the middle and he's the chief. On the other hand, when he has a disagreement with everyone else on the court, then he's not going to be able to kind of control the decision. And that's, I think, what happened in Dobbs. So I think it's a mistake to kind of overestimate his power. On the other hand, I do think that he was the dominant force on the court this past term.
Do you all agree?
I do. I think to pick up on what Roman said, so whoever the most senior justice in the majority decides who gets to write the opinion, and the Chief Justice is always the most senior. And so, as Roman said, he assigned a number of really important opinions to himself. Maybe took, if the New York Times reporting is correct, took one back for himself. But I think he was also very strategic this term in how he was assigning opinions to other justices. I saw that in the case I had, the homelessness case, Grants Pass, where during argument, it was, I think, pretty clear that Chief was hostile to our position. And I think Justice Gorsuch was as well. And then you had Justice Barrett and Justice Kavanaugh more in the middle. Well, the Chief got to assign the opinion to Justice Gorsuch. And I think that opinion ended up looking much different than it would have if he had made the decision to appoint it to someone or assign it to someone else. And I think you probably see that across the board. So he did, I agree, kind of take control of the court, not just through the opinions he was writing himself, but also how he was managing the other ones he was in the majority on.
Go ahead, Ann.
Yeah, I was just going to add, I'm always interested to the extent that the chief wants to have as much unanimity as possible and thinks about the court's reputation. And so I was really interested in the case about Colorado disqualifying Trump from the ballot early in the term. He was able to get unanimous opinion in the decision to keep him on the ballot, but then things kind of fell apart, and there was this really fiery concurrence from Justice Sotomayor that the liberals joined, and then this separate writing from Justice Barrett in the middle. But it did seem very important to him to try to get them all to speak with one voice about the issue of Trump being on the ballot. On the flip side, I was then surprised with the immunity decision, and based again on what we know from new reporting, that there didn't seem to be much of an effort in that instance.
Let's put a pin in the immunity case and come back to it. But I'm interested in sort of the dynamics with the other justices. One of the things that I observed this term, and tell me if I'm completely off base on this, is that the women on the court seemed to band together in perhaps surprising coalitions at various times. So you mentioned the Colorado case, Anderson, which was about whether President Trump could be disqualified from the Colorado ballot. And that was a nominally unanimous decision. Everyone agreed that a state could not unilaterally excise someone from the ballot, but they disagreed on whether or not Section 3 of the 14th Amendment required congressional authorization to be operative. As you say, there was a very fiery dissent from Justice Sotomayor. There was also a separate writing, or it was a concurrence, not a dissent. It felt very dissenting for a concurrence. And then there was another separate concurrence from Justice Barrett. And again, she agreed with the other justices in that sort of concurring wing that they didn't need to decide the question of whether congressional approval was necessary to make the Section 3 of the 14th Amendment operative. But she was very concerned that the tone amongst the justices had deteriorated and become somewhat corrosive. So a big part of her writing was really about, can't we all get along? Like, we're sending a message to the country, can we get it together? And then there were some really interesting moments where they all kind of seemed to come together. The EMTALA case, an oral argument, for example, she seemed actually quite skeptical of the state's view that the provision of emergency abortions was not as straightforward as the state would have made it seem. And so she seemed to side with the liberals there too. So thoughts about this? Is it girl power time at the court?
Well, Justice Kagan was here with Professor Murray last week, and you asked her about sort of what difference it makes having women on the court, and she, I felt like, downplayed that a little bit. She said it's important for symbolism and showing people what's possible for women at the highest levels of their profession, but I actually thought an oral argument, it made a huge difference in both the Mifepristone case about access to the abortion pill and also in the emergency abortion case. You had these 4 female justices talking in very graphic terms about women's reproductive health and
pregnancy loss.
And pregnancy loss, and their periods, and the men on the bench just were very quiet a lot of the time. So I thought it did make a big
Justice
difference.
Breyer were still in the court, he definitely would have
jumped
jumped
in.
all in and had
I know something about periods. Steve Breyer.
I mean, I think on Barrett, I do think she was a very interesting storyline generally for a lot of the reasons that you've mentioned. I also think whether you think of it as a 3-3 3/4 or a 5-1 3/4, either way, I think thinking about Barrett as a unique and independent figure makes a lot of sense. I mean, if you go back to my list of 20 cases, I think in 8 or 9 of those cases, depending on how you characterize it, she disagreed with Justice Thomas, which is like a big deal. And then if you think about the Trump cases, the Colorado case, the immunity case, and then also the criminal case, on each of those cases, she was either breaking in some way from the rest of the conservative bloc. In the criminal case, the Fisher case, she actually wrote the dissent. In the other 2 cases, she wrote concurrences that were sort of distancing herself. There was also another big administrative law case, Ohio versus EPA, that raised interesting questions of sort of administrative law and procedure, and she wrote the dissent there, joining the liberal bloc. So I think she really had a big term, and I thought as usual she was very sharp on the bench and very thoughtful in the opinions, whether agree or disagree with her. She's definitely, has not been afraid to assert herself, at least last year, and I expect that to continue.
And you wrote a profile of Justice Barrett, and one of the things you pointed out was that her brand of originalism, sort of history and tradition methodology, seems to be more practically oriented than perhaps that of other conservative justices. And I think we probably saw that most clearly in Vidal versus Elster,
Right.
which was a trademark case concerning the Lanham Act and how to interpret certain provisions of the Lanham Act. Kelsey, do you agree that she's kind of just got a different, more practically minded vision of originalism? And if so, how does that cash out on this court?
Yeah, so I haven't thought about that particular question. I will agree, during oral argument, she is incredibly thoughtful, and she's both, as you say, she's both being practical, she's also thinking about history. I think we're still starting to see what her judicial philosophy is. Recall, she wasn't on the Seventh Circuit very long. She's actually, is relatively young for a Supreme Court justice, and was an academic, and we can see some of what she was writing before. So we're all kind of looking for kind of where she's going. So I don't know that I have enough, Anne probably knows better than me kind of the data points on that. I will say, if any of you are listening to oral argument, I think Justice Barrett is by far the most difficult one to read where she's going. It is impossible, based on kind of looking at the questions she asks, to guess where she's going. I don't know if she's intentionally
Opaque.
holding her cards,
Yeah.
or if she's just genuinely going in with an open mind, and so you see her kind of working through the issues at argument in a way that maybe some of the other justices aren't.
That's go ahead, Ramon.
I was just going to say on Justice Barrett, I argued a copyright case in front of the court a year or so ago. I got a hypothetical question from Justice Barrett that was premised on the fact that, of course, I would be very familiar with the Lord of the Rings series, which it turned out I was not. At which point I got a very, very dismissive look from an otherwise very polite and nice Justice Barrett. So yeah, she asked hard questions.
I was going to say, I get the impression that she is working through it. I mean, in the Trump immunity case, I know we're not going to talk about that now, but she started sort of reading from the indictment in a very practical way. What about this? What about that? And the Idaho abortion case, there was this exchange. You would not have wanted to be the lawyer from Idaho, where she says, "I'm shocked at what you're telling me," and you really felt like she was sort of learning for the first time these new issues.
It's an interesting, that you were talking about EMTALA too, where she was going. It's a fascinating case because, there are transcripts you can read of the argument. From my impression, talking to other folks, your kind of reaction to Justice Barrett and where she was changed pretty significantly depending on whether you listened to the oral argument or you read the transcript. Because what you could hear in the actual argument was her, I think, and she is a very mild-mannered person, getting aggravated with the lawyer for Idaho because she thought he was changing positions. And I think that didn't come through on the transcript in the same way, it was just interesting to me. She also, during argument, when you're in the courtroom, she is leaning forward, she is like keyed in on you and kind of paying attention. She's just very engaged in a way that
Very law professor.
Yeah.
She's also on the end of the bench, so she has to
She has to lean in.
I do think the law professor thing is actually important to understanding her as a justice. I mean, Justice Kagan was, of course, a law professor, but she sort of came into teaching law after, extensive service in the Clinton administration. I think Justice Barrett, especially as relates to textualism and originalism, I think she cares a lot about theory in a way that maybe is more academically driven, and I think that's going to be interesting to see unfold. We've already seen, you mentioned the Vidal opinion. There was a case, the student loan case, I think not this past term, but the term before that. She had very thoughtful comments about the major questions doctrine and how it intersected with textualism. So, very interesting to watch her kind of unspool her thoughts on this stuff.
Justice Barrett is the second most junior justice on the court. Obviously, Justice Jackson is the most recently appointed. I thought it was really interesting that there was a lot of press coverage about Justice Barrett going her own way and showing these glimmers of independence, where I think we also saw some flashes of independence from Justice Jackson that didn't get quite as much coverage. So I'm thinking specifically of her joining the conservative wing in the Fisher case. For example, Fisher was the case involving the prosecution of the rank-and-file January 6th defendants, and they were prosecuted under a statute that had been promulgated in the wake of the Enron scandal. And so the question for the court was whether the statute could plausibly be applied to something like January 6th as opposed to the concealing or destruction of documentary evidence in the context of Enron. And Justice Barrett parted ways, as you noted, and joined the liberals in that case. It was fine to use the statute in that context. But Justice Jackson joined the conservatives, and according to that reporting from the New York Times, used her vote to extract some concessions from the conservatives and how that decision was written. Is she also kind of a wild card in terms of the liberal wing? And are we likely to see more from her? Like have her be more of a leader and sort of use her position in more strategic ways?
I think I haven't studied this carefully, but I think that in the big cases of the term, she did seem to align mostly with the liberals, but felt compelled to explain when her reasoning was different. And where I feel like, again, in the Idaho abortion case, it didn't affect the outcome there because you had Sotomayor and Kagan joining with Kavanaugh and Roberts and Barrett. But she does, she's doing a big book tour right now. Her memoir is out, so I got a chance to talk with her. And I asked her about the separate writing and when she feels compelled to do it. And she said, well, a lot of times we disagree on how to get there. And I think everybody should know when we have those divisions. So I think she'll continue to do that. And then in the criminal context, she's often joining with Justice Gorsuch on some of those areas with her sentencing
Reflects
background.
her public defender past, maybe joining with his libertarian inclinations.
Yeah.
Yeah, I was going to say the same thing. She is the only former public defender on the court, and so you can see that coming out in a case like Fisher. It's interesting. And, we're talking about the January 6th, right? Folks know which one we're talking about. We throw around the names like.
I explained
well,
it.
Yeah, you did. Okay, good. You got that one. When it comes to criminal law, when it's white-collar crimes, you tend to have the more conservative justices more sympathetic to the defendants, and then it'll kind of flip. So this is Justice Jackson joining the conservatives, and I don't know if this is really a white-collar crime or not, but for whatever reasons, the sympathies tended to be on the conservative side. I think you also see she's very active at oral argument, and I suspect that as the junior justice, right, this is her chance. Whereas at conference, she's going to be the last one to talk. During argument, you, I think, really see her trying to influence her colleagues and kind of putting her theories out there and seeing if she's getting any traction. So as opposed to Justice Barrett, who you can't tell a thing about which direction she's going in, Justice Jackson is putting her cards on the table, and she'll often sometimes kind of push on something, kind of an alternative argument or some other way of getting there, just to see if it gets any traction. She did that in both of my arguments last term as well. So I think she's really interesting, and we'll see.
Well, I want to talk about one of your cases, Kelsey. So Grants Pass specifically. I think it's a case of major interest to the students. This involved a challenge to an Oregon ordinance that criminalized being outside in public places, which obviously applied to everyone, but was felt most keenly by those who are unhoused. And the court upheld the city's prerogative to pass those ordinances. What do you think will be the likely consequence of a case like Grants Pass, and what to you stood out in the court's decision?
Yeah, so as Professor Murray said, you will hear a lot about this being the camping ordinance that was at stake, and that's how the majority opinion describes it. But camping was defined under the ordinances as sleeping anywhere at any place outside with a blanket for the purpose of maintaining a temporary place to live. And that language is really important because it meant that the ordinances apply to homeless people in a different way. If I sit on a bench with a blanket around me, I'm not setting up a place to live because I have somewhere to live. So this was a set of ordinances that were specifically directed by purpose and effect, this is in the record, to target homeless people, make it so uncomfortable that they would have to leave the city of Grants Pass. The city said that they should move into federal wilderness outside of city limits and kind of set up camps out there. So whatever there are lots of really complicated questions about homelessness having to do with encampments and safety. And this case wasn't about any of that. It's really just about the fundamental right to exist in your community. And I preface it with that one because you don't really see that in the majority opinion. I think that kind of factual narrative there is a counterfactual narrative. Justice Sotomayor did a nice job of explaining what was actually going on. But when you understand what the case is about, right, the right of cities to banish impoverished people from their communities, the consequences of it become, not just the cruel and unusual nature of treating human beings this way, but also what happens when Grants Pass pushes all of their homeless folks into Medford. And then Medford says, well, we didn't want to have a whole bunch of homeless people here. Let's do the same thing, but we'll make the jail time a week or a month. And then we end up in this escalating banishment race. And so we end up in a place after the court's opinion where, they said that there was no Eighth Amendment problem with this. You could even have a state, like the state of Kentucky or Florida has actually done something along these lines that says anyone who sleeps outside at any time while homeless is going to be put in jail and then push literally the entire homeless population into Georgia. I don't know where we
Go from there.
go from there. I do think, I can't think of a Supreme Court decision in recent years that inflicts as much suffering as this one, or unleashes the suffering, right? It unleashes the capacity of cities to cause enormous suffering. So my hope is, I think Justice Sotomayor did a beautiful job of kind of articulating what was really at stake in the case. Justice Ginsburg used to talk about the dissenter's hope, the idea that when you write down for posterity kind of what was actually going on and what the law should be, that maybe in some future generation they'll be able to look back and have a roadmap. So my hope is that, we look back 40, 50 years from now, this decision will be as much of a moral blemish on our country as Korematsu or Plessy, the idea that you could criminalize the existence of homeless people. So I feel pretty sad about it. I think the consequences are profound, and I hope we come up with some way of grappling with them.
They also emphasize, this really is a legislative issue, and so a lot of sort of focusing on which branch was institutionally competent to address this.
But the thing is, the reason we have a Bill of Rights is to be this stop, right, this safeguard where, municipalities, local governments have all sorts of authority to legislate to deal with social problems. The point is that they can't cross the line where they start, whether it's the Second Amendment or the Fourth Amendment. The court loves to recognize this in the Second Amendment context, right? McDonald talks about this, Justice Alito's opinion, right? You can solve social problems through legislation up to the point where you start infringing on individual rights. And I can't think of a more profound individual right than the right to exist in your community. So this should be, if the Constitution does anything, I think this is where it should. Sorry, I'm back in oral argument mode. Although these are the things I did not say during oral argument.
You did not. I remember.
Yeah, I had things to say that I did not say. So thanks for giving me a chance to vent about it. Yeah.
And a lot of our students are really interested in the two abortion cases that actually didn't really get decided on the merits. So FDA versus Alliance for Hippocratic Medicine and Moyle versus Idaho. The first was a challenge to the FDA's approval of mifepristone, the second drug in the two-drug medication abortion protocol. And then the second case, Moyle, was about the Emergency Medical Treatment and Labor Act, which requires all hospitals in receipt of federal funds, which is most hospitals that administer the Medicare or Medicaid program, to provide stabilizing emergency care, which could include abortions to all patients that present regardless of their ability to pay. And the question in the Moyle case was whether the Idaho law, which prohibits abortion in many cases, whether that conflicted with EMTALA. The court never actually decided this, and that kind of raised my spidey senses a little bit. Why wouldn't the court address that question? In the mifepristone case, they said the litigants the petitioners lacked standing to bring the case. In the context of Moyle, they said that that certiorari in the case had been improvidently granted and that they ought to have waited. But I could have told them that they ought to have waited earlier. What do you think explains that unusual set of very procedural decisions?
Yeah, I thought the Idaho case was one of the most surprising of the term to me. In January, this was on their emergency docket, the shadow docket you hear a lot about, and it was the same day they announced the Colorado ballot case. So this came sort of very late on a Friday, and
it always comes
the order comes out, and I really had trouble understanding what they were doing. And they said, we are going to allow the Idaho law that had been blocked to fully take effect, but we're going to put it on our calendar before the Ninth Circuit has ruled. And I thought that was sort of an odd posture to take when they hadn't had the Ninth Circuit hear oral argument. And then, again, the argument itself was really revealing. We had Justice Barrett saying she was shocked. Justice Barrett and Justice Kavanaugh had lots of questions about the facts on the ground. So I think what happened was they realized they messed up. They shouldn't have gotten involved that soon. And then it seemed like the liberals had some leverage and were able to say, okay, we'll go along with you and dig this case as long as it stays blocked in the meantime, and that women have access to emergency care. And there were lots of examples of hospitals having to transport pregnant patients on a helicopter out of state, patients being denied care. So I think they realized, after the fact, maybe you have other opinions about it. But
I mean, some
yeah.
cynical court watchers,
Yes.
me, thought it was unusual that both of the abortion cases got decided on procedural grounds when abortion is actually a very salient issue with the electorate, and we are going into a major election, and wondered, perhaps cynically, if this was a ploy to keep the court out of the election cycle.
Well, I think it was interesting. Justice Breyer, I think it was right before the emergency abortion argument, he also had a book come out and was giving a tour and was asked about sort of these abortion cases coming back to the court so soon after Dobbs. And he said something about the conservatives don't want pregnant women dying on the emergency room table. And I thought, well, this is exactly what's
Yeah.
going on here. One quick thing about the mifepristone case, the access to the abortion pill. I think what's most interesting about that is the way that it got to the court. This is one of those sort of judge shopping cases. It was filed specifically in Texas in a single member district where there's only one judge who has well-known anti-abortion beliefs, and then it went on to the Fifth Circuit, and this was one of those examples of the court saying, we're not going to go this far. But this is definitely one to watch. I think it could come back with some of the Republican-led states bringing the same challenge, and we'll see.
The EMTALA too, because
What
there's
happens.
also a challenge in
Exactly.
Texas that is also percolating
Yeah.
right now.
Yeah.
Oh, sorry.
Can I ask you about?
Yeah.
Okay, so Roman, you argued, I think probably the blockbuster case of the
Unless you're
Loper-Bright.
Donald Trump.
Oh, that's right. I keep, how did I
he has a
forget
different
that?
favorite case.
You're right. That's a different blockbuster. Before Donald Trump, you're the second most blockbuster case, Loper-Bright Enterprises versus Raimondo. I am told that we can't really get into it because there's going to be another forum, and it's going to be all about administrative law. Write it down. You're going to want to be there.
I hope you have a smaller room.
No, I mean, this club has everything, administrative law, everything. So there are actually a lot of administrative law cases on the docket this term. Loper-Bright/Relentless, the case that you argued. There was SEC versus Jarkissi, which involved the enforcement of SEC regulations in administrative tribunals. There was a CFPB case about the funding structure for the Consumer Finance Protection Bureau, Corner Post, about sort of when you can bring these claims challenging agency regulations. Many of these cases, both in the context of administrative law, but just across the whole term, a lot of these cases came from the Fifth Circuit. What's going on with that? What is the role of the Fifth Circuit? Is it really just kind of a laboratory for sending things up to the high court? And is there a role that the Fifth Circuit is playing vis-a-vis the justices and how they frame their decision-making?
Well, I think, look, a lot of these administrative law cases are being filed there because litigants recognize that tends to be a more favorable forum for challenging agency action. I sort of suspect, maybe I'm wrong, maybe I doubt, and there would be much disagreement here, if President Trump were to become president again, I suspect that the Ninth Circuit will get very busy with a lot of these challenges to Trump administrative actions that you can imagine coming up. That's what happened last time. So I think the kind of venue shopping, forum shopping consideration is real, and that explains a lot of it. I also think that you have a number of judges on the Fifth Circuit who are very smart and are willing to sort of think creatively about certain areas of law and are coming up with some legal theories that is getting the court's attention. I think one of the headlines when I said earlier that there was nuance in the kind of top 20 cases. I think a fair number of those cases are ones in which the Fifth Circuit was essentially overruled for overstepping.
Yeah.
And so I think that is an interesting dynamic. I think it shows that there's nuance in the court. I also think it shows that maybe the Fifth Circuit's a little out of step with some of the other circuits.
Okay, let's talk about Trump versus United States. So this was the immunity decision that everyone was waiting for. The court took the case in February, slated it for argument on April 25th, I believe, which was the absolute last day of oral arguments of the whole term, and then it decided and issued the case on the very last day of the term in July. What was most surprising about this decision to all of you? Roman was not surprised at all.
So I tend to agree with my former boss, the Chief Justice, in most of his opinions. I think this was one that I did not like this opinion as much as I liked the opinion in my case that he wrote in the Loper-Bright case. I thought it was a little bit surprising in its vagueness on certain important points, and in particular, so the court ended up, I'll probably butcher this, but it ended up essentially saying there's sort of three categories of presidential conduct as it relates to immunity. When the president is acting purely in his personal capacity, there's no immunity at all. So that sort of category is easy. Then it said when the president is acting in his official capacity, there's sort of two different subcategories. One is where the president is exercising sort of exclusive, preclusive authority that Congress cannot interfere with under any circumstances. And there, the president gets full immunity because Congress can't mess with what he's doing, he or she's doing. The middle category is the one that is, the fuzziest to define. I think it's essentially official conduct where Congress does have a role. And the court basically said that in that circumstance, there's
And that role could be like passing a criminal law.
like passing a criminal law or regulating certain, aspects of how the president's exercising his power. And I think the holding of the case was that in that middle category, there is at least presumptive authority.
Yeah.
So the court kind of leaves open this question in the middle category of whether the immunity is absolute or not, which is a huge question. In fact, some might say that's like the question. It kicks that back down. In this case, I think Judge Chutkan's going to have to address that in the first instance, which is sort of an odd way to resolve the case, given that no one thinks she's going to be the last word on this issue, and it's like kind of like the hardest and most fundamental question in the case. So I think it was vague as to that. I think it was a little bit vague as to the boundaries of the middle category. I think the court also, a lot of the focus of the oral argument was on some really hard hypothetical questions about, can the president order SEAL Team 6 to do X, Y, or Z, and assassinate a political rival, and can Congress ban the president from giving a pardon in exchange for a bribe? These are hard, important questions, and I felt like the dissent played them up. They were very much the subject of oral argument. It's kind of fuzzy exactly how the opinion deals with those scenarios, so I thought that was a little bit sort of fuzzy. I do think the opinion's been controversial on both the right and the left. In different ways. But I do think that at its core, it may end up that the bottom line, like holding of the case and how it plays out in practice, might not actually be that far from what the special prosecutor, Jack Smith, was arguing, at least with respect to like what conduct can be prosecuted or not. Jack Smith has filed a new indictment that seems to take the position that most of what he was charging before is still chargeable. We'll have to see. But the thing that surprised me was that the decision was not more clear or precise prescriptively about how this is all supposed to work going forward.
Is that your take on it too, Kelsey?
Yeah, I was going to say the same thing. It's a very long opinion that says lots of things that don't actually answer the question in this case. That at least presumptive immunity means it might actually be absolute immunity. Right. The court didn't answer, and that's as Roman was saying, it's that big middle category of official duties that are kind of peripheral to core constitutional duties. That's going to cover most of what's at stake here. And so to not answer that question, I think is...
And to take months to not answer it.
Right. And so what it does is it kind of kicks the can down the road. As Roman was saying also, Jack Smith has now filed a new indictment. I think he removes the communications with the Justice Department and with White House kind of counsel, but he left in the allegations relating to Trump's kind of communications with Mike Pence. And I'm not sophisticated enough to know kind of what his theories were on why that would be okay. And I mean, we'll find out. I think he's got to file his brief next week on how the immunities play out. I will say what seems to me really profound about kind of the decision when you juxtapose it with Roman's case and some of the other administrative law cases is what you're looking for. I don't want to get into your administrative law panel.
It's going to be lit.
It's going to be amazing. I wish I was going to be here. I would say what to keep your eye on in this space, or in everything the Supreme Court does, is how power is being transferred among the branches. So Loper-Bright, and I think Jarchese and Corner Post as well, are cases that are transferring a huge transfer power from the executive branch, which for a long time, kind of the assumption has been as a matter of separation of powers, Congress makes the law, and then the executive branch kind of experts within the agencies decide things like whether amino acid polymers are proteins within the FDA, organic statute, or whatever it is, right? And so this is, no, we, the courts, are going to decide those things in the first instance de novo. Just to compare that in the Trump case, right, there we have two kind of parades of horribles on either side. One is that presidents are free to order SEAL Team 6 to like, assassinate all of their rivals, and that seems really bad, and you should be able to put in jail for that. On the other hand, we don't want presidents to be able to be prosecuted for political reasons, and they should be able to do their jobs. It seems to me that the answer to that is to allow courts to do their job, which is when someone is prosecuted, a former president is prosecuted for something, they can determine, well, did they actually commit a crime, or is this sort of a political prosecution? Yet that is not where the court went with that, and I don't understand why they don't think courts have the kind of authority and expertise to discern between meritorious claims and not. But
And your colleagues at the New York Times noted that there actually might have been a narrower path forward that was elided in favor of this rather sweeping decision.
Right, and that's the thing that surprised me most. Again, I just thought that the Chief Justice would have done everything possible to try to negotiate something more narrow. It did not surprise me that they didn't like the DC Circuit opinion. The Chief made that very clear at the argument, but there seemed to be, at least at the argument, Justice Kagan and the special prosecutor and Justice Barrett all seemed to be sort of talking about some narrower slice of immunity, and so I was sort of looking for that from the decision.
Narrower and perhaps unanimous, which was not
or
the case
closer
here.
to unanimous.
Closer to unanimous.
One thing I'll recommend to Richard Lazarus, the Harvard law professor who's very close to the
We don't
Chief
know what
Justice.
Harvard is.
Oh, sorry. Close to the chief and taught with him over the summer. He has a column in the Post where he says maybe the immunity decision is narrower than we all think, and maybe it's actually a roadmap for Judge Chutkan. I mean, it's just worth reading it to see how other people view these things.
Yeah, I think it's an open question as to how broad or narrow it is. But that in itself is something that, especially with the chief, who's such a careful legal thinker and writer, that was a little bit surprising. Can I just respond on Kelsey's point about separation of powers? No. All right.
what, you don't agree with me?
I think, look, on the Chevron case, I do want to put a pitch while you
No,
all are here.
we have to put a pin in that because we're going to get to. I don't
Okay,
want
we're gonna get
to.
to
I don't want to like deprive them.
So I get
of-
to say my piece
All right.
and then walk out
Yeah.
and go to DC and,
Let's talk about next term.
Okay.
They're like also going to be lit. This term has everything. Right? There's gun cases, there's free speech, there are questions about sex discrimination. Let's talk first about the Skermeti case out of the Sixth Circuit. So this is a case about a law that prohibits the provision of gender-affirming care to trans youth. And it's been challenged as basically a sex discrimination case. It's not the first time that this conservative supermajority has taken up a question related to the Equal Protection Clause. We saw that in SFFA versus Harvard. But it is the first time since the death of Ruth Bader Ginsburg that we're going to see a sex-based discrimination challenge under the Equal Protection Clause because, as we know in Dobbs, the Equal Protection Clause doesn't relate to abortion. Not true. Anyway. Let's talk about Skermeti. So what do you anticipate the court is likely to do here? What are going to be the big issues and perhaps what might be the coalitions?
Yeah, so for you all, this is a Tennessee law that has two purposes. One is to ensure that minors appreciate their sex and do not have disdain for their sex. And the other is to protect minors from dangerous and risky drugs. And so the things that are prohibited that are issue are puberty blockers and hormone therapy. What I think is really important and gets to the sex discrimination piece of it is the laws prohibit, for instance, someone assigned male as birth who wants to take puberty blockers or hormone therapy to present as a woman or as a girl cannot use them under the law. But if it were someone using the drugs for a reason related to their assigned sex, so someone who wasn't going into puberty a male who wasn't going to puberty, and so you could give testosterone. It's fine to use the hormones therapy and the puberty blockers to appear more like your assigned sex, but you can't use them if you're transgendered. And so, there was a decision a number of years ago, it was under Title VII, Bostick, where the court held that or discrimination against people for being transgendered is sex discrimination, right? And it's because if you were acting like your assigned sex, then you wouldn't get fired. That was a Title VII case. So anyways, you have all of this reasoning in Bostick. Now, that seems to apply squarely here, right? You're being treated differently based on whether you're transgender or cisgender. Now, Title VII is really different than the Equal Protection Clause in what happens after you've identified sex discrimination, right? In the Title VII context, well, then maybe there's a bona fide job qualification or some reason you're allowed to discriminate. In the equal protection context, you then apply heightened scrutiny. Mm-hmm. But the state here has taken the position there's no sex discrimination at all. And I think it's really, I'll be interested to see how the court deals with Bostick, because I think it answers that question.
So for the first years, Title VII is a statute. It's part of the Civil Rights Act of 1964 that prohibits discrimination on the basis of sex. And in Bostock, which was a case decided, I think in 2020, the court said that discrimination on the basis of gender identity and sexual orientation are species of sex discrimination for purposes of Title VII. That's very different from the Equal Protection Clause, which doesn't actually specifically prohibit discrimination on the basis of sex, but has been interpreted to include
right, but
that.
there's no kind of basis in the law
Right.
prior to this that the definition of sex discrimination is different under Title VII than it is in equal protection. Yeah.
Yes, so I'll be looking to see how the court deals with Bostock in this different environment. I think one key thing to look for is the Sixth Circuit opinion from Judge Jeffrey Sutton, who a lot of the conservatives on the court really respect. And in his opinion, he said, I looked this up, that this is one of those sort of new situations, political situations, that life tenured judges should be humble and careful about announcing new equal protection rights that limit accountability of elected officials from sorting out these policy issues. So I could really see the court sort of saying this is a policy issue, we're not going to get
Give it to
involved.
Congress.
I think it
Give
has
to
some
us.
echoes actually of the Grants Pass case in the sense that you have a very hard problem to deal with, a policy problem to deal with, and the question is I think the conservative-leaning justices might view this as a situation where, in the face of a challenging policy problem, are we going to constitutionalize the problem by finding in the Constitution something in the Bill of Rights or in the 14th Amendment that prevents states from acting? And I think in Kelsey's case, where she did a terrific job on behalf of her clients, I think the court basically just didn't disagree with Kelsey's premises that the democratic will gets its way until it hits up against a constitutional provision. It just didn't think that there was a constitutional provision that actually governed in that circumstance. And I think it's possible that the conservative majority might look at this case through a similar lens.
Let's also talk about ghost guns, because the Second Amendment, weirdly, is back at the court again. We had a major Second Amendment case last term with Rahimi. That was the case that Kelsey mentioned, which was about, or actually Ann mentioned it, excuse me, about whether or not Congress could pass a law that disarmed those who had been credibly accused of domestic violence violations. This case is about the assembly of ghost guns. So ghost guns are sort of like kits where a gun is disassembled, and so it's not actually a whole firearm, but once you have the whole kit, it can be put together to create a deadly weapon. And so the question is whether that sort of thing can be regulated under the federal firearms law. And ATF, which is the Bureau of Alcohol, Tobacco, and Firearms, says that yes, we can regulate this as a gun. However, it has been challenged by the manufacturer of these kits that it is not actually a gun and therefore falls outside of the ambit of the statute. What are we going to be seeing here? This is another Second Amendment case, and the court has taken a more muscular approach to the Second Amendment in recent years.
Yeah, I think this will be a lot like the bump stock case from last term, and this was actually a Trump administration regulation that banned bump stocks under the law that regulates machine guns, saying essentially they turn guns and semi-automatic weapons into the same firearm is a machine gun. So I can see a lot of the same discussion playing out. And I think it is a test, really, of Loper Bright, right, in a post-Chevron world. So I think that'll be really interesting to watch, too. So it's not exactly a Second Amendment. I mean, it involves Second Amendment rights, but it's really a sort of statutory interpretation. So I think that I could see them going the same way with ghost guns. The issue with ghost guns, right, is that they don't have serial numbers, and that's why criminals tend to use them. And the Biden administration says that the government should be able to regulate these.
Just like Cargill?
Yeah, it is like Cargill in the sense that it's outside the scope of the Second Amendment, in that really all we're asking is, does ATF have authority under statute? So it's a statutory interpretation question. It's really an administrative law question. What I think is interesting in both of them, particularly Vanderstock, the ghost gun cases, the Fifth Circuit, I think, pretty much accepted the idea that Congress could treat ghost guns the same way as other guns. And I don't think anyone, kind of at least in the mainstream, is arguing right now that you can't do what what the statute does, which is simply require background checks, kind of record keeping on guns. The federal government's point is, why would you keep records and have licenses and background checks for guns, and then you get a kit that you spend 20 minutes putting together? I think they use the IKEA metaphor, right? You wouldn't say that IKEA doesn't sell chairs or desks because you get a box that you put together. And so, it's interesting. I think what you'll see from the court is kind of a pretty technical, what we saw in Cargill, right? Trying to figure out exactly what Congress intended to regulate here. I haven't seen any policy arguments for why Congress wouldn't want to regulate ghost guns in the same way. It's a massive loophole, right, in our federal laws. One set of respondents makes the argument that there's a Second Amendment problem with regulating ghost guns because of our country's long history of personal gun making. So we'll hear more
I think
about
that could be a winner. I don't know. I think it could be a winner. So that's a big case. I think there's probably going to be maybe some election-related stuff in the hopper, that we don't even know about. I mean, that's going to happen as the election cycle continues. Do you think this is a court that's going to be receptive to challenges made in the auspices of the election and how ballots are cast? I mean, are we going to have Bush versus Gore redux? Ooh.
I hope the court.
Spicy.
I hope the court doesn't have to get involved. I think one of the things that the court did extremely well last time around was, especially with the post-election challenges, I think the court rightly denied review in essentially all the cases.
Yeah.
And so I have a lot of confidence in this court that it's going to, try to. I have a lot of confidence in the court that it's not going to try to come in to kind of be politicized and resolve these cases in a politicized way. And hopefully it won't be drawn in by virtue of having lower court decisions that it kind of has to weigh in on. Because I just think that would be bad for the court and bad for the country. And I'd rather just have a good election that people, whatever the result is, people agree that it was legitimate and fair and move on with their lives.
I think that there will be perhaps fewer cases. Rick Casson, election law expert, makes the point that during COVID, a lot of the states were changing their election rules at the last minute, having to do with absentee ballots and signatures. So that was a lot of what was coming to the court then. But I also know that both political parties are already filing many challenges. The court has already gotten involved in a case from Arizona having to do with whether or not you have to show citizenship when you register to vote. So I think even if the court wants to stay out of it, they will definitely be drawn in.
I was going to say the same thing as Ann. There was a pandemic overlay in the emergency docket in the last election that won't be here this time. So I, too, am hopeful that they will stay out of it and we won't see as much of it.
Hope springs eternal. I just want to say thank you to the students who submitted questions via the internet. I've tried to work in your questions into some of my own, so hopefully we've been responsive. It's going to be a bang-up term coming up, so last year was really consequential. I think this year will also be consequential. I'm so glad that we had Roman and Kelsey here to talk about it with us. Thank you so much for today.